Hello, this is Jim Grant. This is Module 4 of Employment Relations. In Module 3, we consider dismissal with just cause. In other words, when employers believe that they have just cause for dismissal, they do not owe a reasonable notice period of termination to employees. In this module, we move to the consideration of what happens when employers don't have just cause for dismissal. So remember, the basic law in Canada, the implied terms in common law in wrongful dismissal law in Canada is that any employee can be terminated at any time as long as they're provided with reasonable notice of termination, unless there is just and sufficient cause for dismissal. So we will move to what happens when there is no just cause. So the agenda for this module then is to define reasonable notice. What is its purpose and how does it work? And we'll consider an exception to reasonable notice, the frustration of the employment contract. We'll consider how we determine what notice period is reasonable in common law. How do we calculate that reasonable notice period? We'll also consider what is meant by working notice and separation package. Separation package is essentially an alternative to working notice. We'll also consider the employee's duty to mitigate the loss of the job. It is essentially the employee's duty to go out and replace with relatively comparable work the position that was lost. We'll also consider another form of dismissal called constructive dismissal. So in constructive dismissal, the employer has essentially constructed a dismissal from a breach of the employment contract, a fundamental change of the conditions of employment that represents a fundamental breach of the contract and gives the employee the opportunity to sue the employer for constructive dismissal. We'll also consider what makes up the damages in a reasonable notice period, what goes into creating the award from the court. And there's a final item here which I will not consider in depth. It is covered well in your textbook and is more up to date perhaps than what I can provide here today. But it's also a very complex case of the Supreme Court of Canada in 2008 called Keys versus Honda. And one of the reasons that it's problematic is that it's complex, and the justice who wrote the decision of the court failed to anchor his arguments in previous decisions. So he created uncertainty, and other labor lawyers in particular argued that the decision may have created new opportunities for employment relations and labor relations lawyers to create new categories of damages for the employee. And so it's a little bit above our pay grade in this particular course, and it's interesting, but it's also complex, and it's not easy to explain at this level of inquiry. So we'll leave it for now. So to once again repeat the basic law in Canada around dismissal, an employee, any employee really, can be terminated at any time as long as he or she is provided reasonable notice of termination or severance in lieu, unless there is just and sufficient cause for immediate dismissal. I should also mention that this is the common law implied term, and so if it's determined that the contract that exists between the employee and employer is not enforceable, then the courts have to imply this term. So it's essentially the law of the land in Canada, and so we build virtually this entire first half of the course around this statement. So what we do in this module is we consider what happens if the employer doesn't have just cause for termination. The employer then must provide advance notice or pay in lieu of notice to the employee. The failure to provide either is called wrongful dismissal. In other words, if the employer cannot provide just cause or doesn't provide adequate reasonable notice, both cases are considered wrongful dismissal. The employee can then sue in a civil court in Canada for damages resulting from that wrongful dismissal. So, and that's unless the length of notice is set out in a valid enforceable contract, which we considered in Module 2. If not, the employer must provide reasonable notice in common law, and so we'll work at determining what that means. So the practical purpose of the reasonable notice period is to provide the employee with a reasonable period of time to locate a position of similar stature requiring the skill or ability comparable to the position from which they were dismissed, or to locate a position for which the employee is qualified or suitable, subject to additional factors such as the length of service. That's probably the key determinant of reasonable notice period. Labor market conditions can also be considered. Industry custom can be considered, what is normal in a particular industry. The age of the employee may be considered, and other circumstances surrounding the hiring. And that's from a guy named Levitt, who produces a massive volume dedicated to the study of wrongful dismissal. He's an employment relations lawyer in Toronto with a private practice. And I've quoted from one of his older editions, but it's still essentially the same understanding today. So the notice period awarded by the courts is frequently far in excess of the employment standards or labor code provisions, and on occasion reaching 2 years or even more. I believe Wallace in 1997 was awarded, I think it was 21 months, and then for Day in the Walmart case in 2001, that was right here in Dartmouth, he was awarded 29 months by a jury in a court decision, and I've seen other decisions that go as high as 33 months from earlier decisions in British Columbia. But generally speaking, the courts consider roughly 2 years to be the upper limit, and you'll frequently see that expressed in court decisions, the written reports. So the leading case in the area of reasonable notice periods is still considered to be Bardall versus Globe and Mail Limited, way back in 1960. The essentials of reasonable notice were laid down, 60 years ago, and haven't changed much since. So in that decision, the justice said there can be no catalog laid down as to what is reasonable in particular classes of cases. The reasonableness of the notice must be decided with reference to the character of the employment, the length of service of the servant. You notice the sort of old-fashioned language here. Wrongful dismissal law actually emerged from an area of law that used to be referred to as master and servant, and you can sort of sense the archaic terms being used to describe an employment relationship. It also considered the age of the servant or employee and the availability of similar employment, having regard to the experience, training, and qualifications of the servant. So that's quite a range of factors that can be considered in determining what a reasonable notice period should be. In 2004, Levitt listed more than 100 factors that the courts had considered to determine reasonable notice periods. But he claimed, and of course since then we've had probably a few more added to that list, and he claimed that 24 or so of that 100 plus had been given substantial or significant weight by the courts. And these narrowed down to the employee's specialization and status. Status refers to their position in the hierarchy, essentially. Are they top of the hierarchy or bottom of the hierarchy? Their custom in the industry and the nature of the industry, the circumstances surrounding the hiring, which is an interesting topic all on its own, and we'll actually cover that in Module 5, I think, in more depth, and the manner of dismissal. So as a result of that 1997 Wallace versus United Grain Growers decision, damages have actually been longer than they were before the Wallace decision. And in a later slide, I believe I will offer an explanation for the increasing length of reasonable notice period. And the courts essentially stress that employers cannot take refuge in the blanket application in the application of a blanket formula, since the individuality of each employment contract must be considered and fairness requires a balancing of the applicable factors. Several studies of reasonable notice have found that a relatively small number of factors, in the range of 4 to 6, I would say, explain most of the variance in notice periods awarded. So in my own dissertation, for instance, I determined the most important factors, and I believe I'll share that with you later in this presentation. I should also mention, too, that what I found in my own survey of HR practitioners that there is a tendency toward the application of a blanket formula in the workplace against the advice of the courts, which is kind of interesting. And I'll talk about that again later on in this presentation. So the key legal issues under the common law of wrongful dismissal, to begin with, as I mentioned earlier, is there an enforceable termination clause in the contract? And if not, then we have to determine what is the length of reasonable notice in common law. And I've just referred to Bardall versus the Globe and Mail as that quintessential and fundamental decision from 1960 that set the stage for largely the way we determine reasonable notice periods today. We'd also need, as the employer, I guess we would need to consider whether the employee should be required to work out the notice period. So that's the concept I was talking about earlier called working notice. If not, how should a severance package be structured? I've also mentioned earlier, what is the employee's duty to mitigate the loss? That is, to lessen the loss. We'll also consider what constitutes constructive dismissal, and if there are other headings of damages that are available. Now, in this course, I really only deal with reasonable notice period. I won't deal with largely I will not deal with the other categories of damages, partly because they're not as frequent, and in terms of management in the workplace, we are trying to avoid additional damages, so we're trying to do the best we can with reasonable notice. And so again, those additional damages are a little bit above or outside of the scope of this particular course, and so we'll leave that for this presentation. So as I mentioned in the agenda, one of the ways that a reasonable notice period is ruled out of consideration is if the employment contract has become frustrated in some manner, and that essentially means that the conditions under which the contract was formed in the first place no longer apply, and it relieves the employer of the duty to provide reasonable notice. So in unusual circumstances, the contract may come to an end without notice because it has become impossible to perform. And some examples of this, what happens if the employee goes to jail, for instance, or the employee loses their professional credentials rendering the employee incapable of performing the job. For instance, just as an example, imagine an accountant, CPA, loses their accreditation for some reason, and the accreditation is required of the position. That would frustrate the contract. And in addition, the prolonged illness of the employee may incapacitate them from performing their job, or making the performance radically different from that which was originally contemplated. But it's also a fairly complex topic, so we'll only be brushing it at this particular point in time. So what is reasonable notice exactly? We know from Module 2 that reasonable notice, if it's spelled out in an employment contract, an enforceable employment contract, it must at least meet the employment standards of the jurisdiction in which regulates that particular workplace. So in Ontario, the Employment Standards Act, what are the minimum standards in the Employment Standards Act? And so the reasonable notice period must at least meet those minimum standards. But in general, in common law, if the contract does not specify in an enforceable way, we have to consider things like the Bardolph factors, that case from 1960, things like the employee's age, the employee's position, the length of service of the employee, the level of compensation, which is essentially, what they're referring to there is essentially the status of the employee. Where do they fit in the hierarchy of the organization? How much status would they be accorded in that particular organization? And the amount of time it would take to find alternative employment. Now, these are the basics, but Bardolph also leaves lots of room for additional factors to be considered. I should also mention there is a problem right off the bat here, which is kind of a statistical problem. We often find when we're doing quantitative assessment of reasonable notice periods that age and length of service are correlates. They vary together, which makes sense, right? The older an employee gets, the longer their service. So when we include both of those factors in a statistical analysis, we get some confounding of the results. The more important, in my own experience, the more important of the two in determining, statistically what a reasonable notice period should be and what factors should be considered, the length of service is far more important than the employee's age. And the employee's age really only, in most of the cases that I've read anyway, the employee's age really only becomes a factor if it's either, usually if it's either, the employee is either very young or fairly old, especially approaching normal retirement age. As I mentioned earlier, the Bardolph leaves open the possibility of other factors, and Levitt, the labor lawyer from Toronto, who documents these decisions very precisely, has identified dozens of factors. And so some of the additional factors that have been considered, and I'll explain in more depth later in this presentation, some of them anyway, whether the employee was lured from a quality employment, a good job somewhere else. Were they enticed? Were they induced to leave secure employment to join the employer and then terminate it without just cause? That can increase the length of reasonable notice period awarded by the courts. The economic conditions, usually a fairly minor consideration, but certainly in extraordinary circumstances it could be considered. Imagine somebody trying to find replacement work in a small community, like a small city or a small town in north of Canada. You might have to completely disrupt your life to find a comparable job in the south, and so that might add to the length of notice period. And we also, I've already alluded to several times now, the Wallace decision, which essentially created an additional category of damages that can be awarded under reasonable notice in the courts, and it results from the manner of dismissal. Was the employee treated with respect? Did it create real damages, substantive damage to the employee in terms of perhaps their psychological health or their ability to find new employment? Both factors in the Wallace case back in 1997. Some others that might apply, some personal circumstances of the employee, including health, the ability to relocate, communication skills, pregnancy, and quite a number of other factors as outlined in Levitt's documents. So if I didn't mention already, this table is from my own work, my doctoral dissertation. I examined about 165 wrongful dismissal cases, and about 105 of them roughly dealt with reasonable notice period. In other words, in about 2/3 of the cases, the employee won. They won reasonable notice from the courts. And so in this table, you'll see my calculation, my quantitative examination of what makes up the reasonable notice period in all of these cases taken in a combined manner, not at a case-by-case basis, but in a combined statistical manner. So if you look down the left-hand side of the table, you'll see the factors that I identified in the cases, and in the two right-hand columns, you'll see the statistical result of my examination. So for those of you who are statistically inclined, I used regression analysis, and the dependent variable in this case was the length of reasonable notice period in months. So if you look down the left-hand side again, you'll see that the things I was tracking were issues that arose in the case. Was for instance, I'll go down through the list, was the employee asked to change the conditions of their employment voluntarily, or was a change forced on them? That's involuntary change. Did they have, before the dismissal, did they have satisfactory performance? Was it noted? Was progressive discipline used before dismissal? Was procedural justice, were there issues of procedural justice? Now you may recall from the last module, that some of the tests employed by the courts in determining just cause include progressive discipline. That's the test of contextuality, proportionality, and contextuality. So if the employer used progressive discipline, it's an indication that there was a more progressive, proportional response to poor performance or misconduct, resulting eventually in dismissal. Procedural justice we talked about, was a hearing provided? Did the employee get a chance to tell their side of the story? Where they provided a candid explanation, and so on. Next, did the employer fail to provide adequate warning to the employee that their job was in jeopardy? Next, were performance standards effectively communicated to the employee? Were they consistent? Were they realistic? And so on. I also tracked whether this was a decision from before the Wallace decision in 1997 or after. And I'll get back to that in a second. I'll also I've also tracked whether the employee was, the court noted that particularly that the employee was in a vulnerable, an especially vulnerable position. And again, I'll talk about that, the results of that in just a second. I'll also talk about whether the poor performance or misconduct of the employee was thought to be of a serious nature or not. And then some factors that are not related to the performance of the employee, but to the conditions of employment. Was the employer a large employer? That was the employer larger than 500 employees? What was the length of service of the employee's tenure? What was their occupational status? Remember, I mentioned earlier that the higher in the hierarchy the employee is, the longer the notice period, generally speaking. And so I actually, when reading these cases, I created a 5-point scale with the employees at, in the executive ranks, as an example, getting, the highest score, a 5, and then the lowest level employees, say clerical type employees or unskilled laborers or something like this, would be at the bottom of the hierarchy. I also tracked whether the employee had limited job prospects after being fired, and whether they were induced to leave secure employment from before their new employer. I also tracked what industry they were in this case, whether it was manufacturing or other, what jurisdiction they were in, and the two biggest jurisdictions in Canada for this study were Ontario or British Columbia. And I also tracked the employee's sex, and in particular I noted whether the employee was a female or not. And so when you look down on the far right-hand column, what you'll see is that the statistically significant factors, so wherever you see an asterisk or that sort of cross, I'm not sure what that's called to tell you the truth, but that's a statistically significant finding. So for example, any decisions that came before the Wallace decision in 1997, the reasonable notice period was shorter by almost 2 months than decisions that came after Wallace. So it's interesting, it seems to indicate that the Wallace decision itself had an effect on all reasonable notice periods that was almost 2 months longer than it had been previous to Wallace. And the next factor, vulnerability, were essentially where Wallace damages were awarded, or what is referred to today maybe as augmented damages. The typical length of increase when the employee's vulnerability was noted by the court was 3 months additional notice. So an augmented damages, which result from the manner of dismissal, where the employee is particularly vulnerable in the manner of dismissal and the employer fails to take that into consideration, that can increase reasonable notice period by 3 months. The other factors that are statistically significant, it seems that large employers generally will have to pay longer notice periods than small employers. So that, again, that's employers with more than 500 employees generally will have to pay more reasonable notice period than employers with fewer than 500 employees. Well, why would that be? Possible explanation is that the larger employer has more resources, and so the courts will, consider them better able to cover the damages. A second explanation, possible explanation at least, is that the large employer is more likely to have a more sophisticated human resource function. And given that, why did the larger employers still wrongfully dismiss the employee? And so it may be an additional punishment for not doing their job as well as they should. Now, I'm speculating a little bit here, that's for sure, but if there's a third explanation, maybe you can offer, maybe you can suggest that. But those are my two at this moment. Now, one of the most, I've mentioned this before, but one of the most important factors for determining length of notice. The most important, really, is the employee's length of service or tenure. And so that's roughly a third of a month for every year of service. So if I had worked for 20 years, let's say, I could expect that my tenure, my length of service, might contribute roughly 7 months to the notice period I would be awarded, in addition to the other factors. Occupational status might also increase the length of notice period. So from the bottom of my scale, which was 1, lowest status employee, to the top 5, there's a gap of 4 points. And so if we take the 1.34 and multiply it by 4, we might see something as much as more than 5 months difference between a low status, sort of entry-level kind of employee, low-skilled employee, compared to somebody at the top of the hierarchy of the organization. And then finally, this is a little bit of a problematic result, but because there weren't very many cases in my sample that dealt with an employee who was induced to leave secure employment before they joined the employer. But it's still pretty strong. It's still a pretty strong result. If I had been, let's say I was terminated by my employer, and that employer had induced me, provided, extra sort of inducement for me to leave my secure job to come and work for them, and then they fired me, that could result in almost 4 months of additional damages, reasonable notice period, in the courts. The courts do not like employers taking employees out of secure employment and putting them at greater vulnerability, greater risk. None of the other factors really became significant in my modeling here. One exception to that I might note is that in the middle column under Model 1, you notice that satisfactory performance might increase the length of notice period, but that washes out in Model 2. So it is apparently an artifact that might have been created by one of the other factors that I included in Model 2. It loses its significance, its statistical significance in Model 2. Sorry, I'm getting a little dry. So that's kind of interesting. So the working notice is essentially a decision of the employer to require the employee to continue to attend to work during the notice period. So as an example, let's say I've told an employee, I'm the manager, I've told an employee that they have, that their job will end in 3 months. And I require them to work till the end of their notice period. So that would be a working notice. Now, in most, my own experience tells me that in most cases, an employer probably wouldn't want an employee to work out the balance of their notice period, partly because a terminated employee can get up to mischief. What will they do in those final 3 months? In my example, for instance, will they be tempted to, just show up but do very little? Will they be tempted to gather information that they can use in their next position? Anyway, there you can probably imagine a whole bunch of different scenarios. So in my experience, most employers would actually not employ a working notice period. But I can tell you from experience that in one of my jobs, when I was a research coordinator for the Nova Scotia Teachers Union, as it turned out, and my position and a couple of others I was being downsized for budget reasons, apparently. And I had in my contract, a valid contract, enforceable contract, I had a 3-month notice period specified. And the employer wanted me to work out the balance of the contract if I had any work left to do. And as it turned out, I really didn't. I'd completed any substantive work that I already had begun at that point, and I told the employer that. But if I had any reports left to complete, they wanted to require me to work out the balance of that contract. So that's in my experience, that's unusual, but it does happen, obviously. If the employer does require me to work out the balance of my contract, however, they must provide an opportunity for me to undertake a job search, time off to go do an interview, for instance, or allow me to, create an up-to-date resume, and perhaps even contact potential employers from my office. So in other words, the employee must be in a position to use the notice period for its purpose, to replace with substantially comparative employment somewhere else. So if the employee is not required to work out the balance of their notice period, maybe we want to create a separation package from their position. And so there are a number of different ways that we can create this package. One is, let me continue to use that 3-month example. One might be to offer a lump sum payment that would be the equivalent of wages or salary, wages, and or benefits that the employee would normally earn in that 3-month period, and simply pay it as a lump sum as they exit their position. Another way to deal with it might be to simply continue with the salary or wages that they normally would have earned and benefits till the end of that 3-month notice period. So they, as the employee, I would simply continue to receive my paycheck for another 3 months and be covered by the benefits, for perhaps contributions to my pension plan or health insurance and so on, or some combination of the two. And generally speaking, the employer wants the employee to sign off, and I would put sign off in air quotes. Essentially, you want the employee to agree that they're being reasonably and fairly compensated for the reasonable notice period. That might include giving them an opportunity to take the separation package to a lawyer to ensure that they understand the implications of the separation package. So here's a sample question, and this one actually appears in your list of questions for for test 1. It has some complexities. It's fairly straightforward, but it has some complexities, and it's not easy to determine an outcome here. So Suzanne owns a small restaurant. Robert, the restaurant chef, is an excellent cook, but he is very temperamental. He becomes angry and abusive with the other kitchen staff and waiters over the slightest mistake. It has reached the point that many members of staff dread working with him. Suzanne has spoken to Robert about this issue many times over the years, but if anything, it is getting worse. Robert simply tells her that he cannot tolerate incompetence among the staff and that shouting and yelling at them is just his way of coping with stress. Suzanne has decided that enough is enough. She is going to terminate Robert's employment. For the facts, Robert is 39 years old and has worked for the restaurant for 7.5 years. So the questions you'll be asked if this appears on test 1 would be similar, but not necessarily identical to what comes next. So a possible question about this fact case might look like this. In your opinion, is it likely that a court would find that Suzanne had just cause under common law to terminate Robert's employment? Explain your answer. List the factors that favor a finding of just cause and those factors against. So what I would recommend, remember in class last week, I constructed a T account with arguments for just cause on one side and against just cause on the other side. So let's see what that looks like. So here's the T account, and I must warn you right up front that this may not be a complete answer. And in fact, students who really dig in to the tests of just cause quite often surprise me with new arguments that I hadn't anticipated myself, and that's part of the fun of practicing the law. I think it's in constructing these arguments effectively in a way that is persuasive when you need to challenge a policy or a practice or a decision. And so don't consider this an absolute, the last sort of answer to this question. It's simply, what I've got here right now is simply a suggestion. So some of the arguments that seem to favor the employer is that we might argue that progressive discipline was used. And that the employee created a poison work environment. So go back to Module 3 and look at the various causes and find an argument in that list of causes that seems to align, and it may be multiple arguments to tell you the truth, because this particular case could be a case of poor performance or misconduct, and so there may be a number of explanations that the employer could offer for why the chef had to be terminated. On the other hand, and don't forget, if in most of these questions that will appear on test one of the first things I may ask you is, was there a prima facie case? I notice I made a mistake here in my notes. Prima facie usually will be italicized if you're writing it in a report. And it's italicized to set it apart from the rest of the text, as it is a Latin term, a Latin legal term. So it's a specialized use of Latin language to describe a principle in law. And it means literally, I guess, on the face of it. Does the employee have a prima facie case? And so, as I mentioned in class last Tuesday or Thursday, I don't remember which, the test is, was the terminated employee actually an employee? And quite often you'll find the employer may, or sometimes at least, you may find that the employer will make the argument that the employee in fact wasn't an employee but may have been an independent contractor. So sometimes you'll have to determine, was the employee actually an employee? The second part of the test is, were they terminated? And again, sometimes in court, employers may argue that the employee in fact resigned rather than was terminated. So the court has to determine, was the resignation real, or was it simply the result of a termination and the employee attempting to make the best of a bad situation? So the court is right on top. The employer will not get away with insisting that it was a resignation if in substance it wasn't. If in substance it was actually a termination. Now, in fact, the employee in this case could argue that there was no progressive discipline, because even though the employer, Suzanne, talked to the chef, she didn't actually discipline the chef. She didn't. There was no warning that his job, and I'm assuming he's a he, I'm not sure. I'll go back and read the case in just a second, but the chef was not given a warning that his job was in jeopardy. And so there was no verbal warning, there was no written warning, no suspension, so there was no progressive discipline. A conversation with the chef is not the same as discipline. And so it could be argued, in fact, that Suzanne, in fact, condoned his behavior by not providing a discipline at different stages before dismissal, by not providing a consequence for that behavior in the workplace. She is essentially condoning that behavior. Again, you'll need to go back to Module 3 and read through both my description and your textbook's description of the test of condemnation. And as well, what is the other test that I referred to here is, was the dismissal proportional and contextual? And so you'll need to, in order to really do a great job of answering this question, you'll need to refer to those, and it's a relatively small section of your textbook. I've cut the level of things that you need to study down to the essentials. But if you don't go back and do that, you're not going to provide a good answer to this question. So, okay, so let me move on. So as I mentioned, Suzanne has spoken to Robert many times. His behavior has created a hostile workplace, a threatening workplace to the other employees, and he doesn't seem to be able to perceive his faults. So there is a good reason to try to modify his behavior. However, on the other side of the T account, he's had relatively long satisfactory service, 7.5 years of service at the restaurant. And as I mentioned before, is it possible that she condoned his behavior by not issuing disciplinary measures along the way? And then finally, there's nothing in the facts of this case to indicate that she let him know that his behavior does not meet standards. She alludes to it, but what did that discussion entail? Did she draw his attention specifically to a standard of behavior that was required of him? Did she offer him assistance and support in making a change of behavior? Did she apply progressive discipline? And did she let him know that his job was in jeopardy? So these would be all parts of what a proportional response would look like. So the question that might finally appear on your test would be, in your opinion, is it likely that a court would find that Suzanne had just cause under the common law to terminate? And you would need to explain your answer. It's not a simple yes or no. It's yes or no plus explanation. And you, again, for the explanation, you go back to the arguments that you created in your T account. So to support your answer. So in this case, I would say no, there wasn't just cause. And again, I made this argument already, but speaking to the chef is not the same as specifically warning the chef that his job is in jeopardy. And she didn't apply any previous discipline for that bad behavior, so there was no progressive discipline. And another thing that may come up, and this, I remember having this discussion in class with students at one point. There is, if any of you watch, a reality TV, Chef Gordon or Gordon Ramsay, or he behaves very, very badly in his kitchens, and and so there's a question of whether that bad behavior is an industry norm. Now, it's just because it's an industry norm, in my mind anyway, just because it's an industry norm doesn't mean that it isn't something that, as an employer, I would would not want to correct. I would want to correct, because if that chef is creating difficulty in staffing and increasing my costs as a result, I'm going to want to deal with it. It's not a healthy workplace. My other employees deserve a healthy workplace, a safe and healthy workplace. And so I want to create those conditions. But, that should be considered in your determination. And then the other factor is that he's had relatively long satisfactory service with the employer. There are other than this bad behavior, there apparently were no other any other complaints against the chef. Now again, some of you are going to say, well, we need to know more. In each of these cases, you're given some facts, and based on those facts, you need to assemble your arguments. In any case, there would always, we could always make the argument, well, we don't know enough. But at some point, you're going to have a certain number of factors, certain number of facts to deal with them. Make your arguments. There might be occasion when you have to make an assumption, but generally speaking, a reasonable assumption, but generally speaking, you deal with what you're provided and make the best arguments you can. And that's in the end, that's the test. That's what I'm looking for. When I grade test 1, it will be how well did they assemble their arguments either for or against, and then in their final decision, how did they let those arguments influence the decision that they made? How do they support that decision given the tests that we've previously covered, and how did they assemble those arguments, those tests, into arguments in the current case? So I included this case in this particular module because it's also possible that Suzanne wants to terminate the chef, even though she may not have just cause at that point in time. And so she, under the law in Canada, unless there is some other enforceable contractual language that supersedes the common law, she is entitled to terminate any employee with reasonable notice. So what if she wants to do that in Robert's case? So she would need to offer reasonable notice. So she decides that she will offer Robert a package. In your opinion, what would be a reasonable offer in these circumstances? Explain your answer by identifying at least 3 factors that a court takes into consideration in determining the appropriate amount of reasonable notice of termination or pay in lieu required under the common law. So I include some of the Bardol factors. We know Robert's age. He's neither old nor young. He's 39 years old. And generally speaking, I would think that would make his age a relatively neutral factor. His position, he is a chef. So he's, in terms of the hierarchy of the restaurant, he is, relatively senior he is the senior person in the kitchen. And the only other person, it seems, in this particular fact case, who outranks him or has higher status than him would be Suzanne. It's possible that if this was a chain restaurant or something, there might be regional managers or something like that. But in terms of this particular restaurant, he's relatively senior, but not the most senior. And then on the other hand, he's not an unskilled worker. So he fits in somewhere up the hierarchy, but not at the very top. His length of service is 7.5 years, and that's substantial. And we know from previous discussion that length of service is probably the most important factor in determining length of notice period. His compensation, I don't know where I got this. I don't think we even knew what his compensation was, but just assume he has a moderate amount of compensation. And we don't know anything about the availability of similar employment, but his skills as a chef would seem fairly marketable, And I would argue that it might depend on the market, the labor market in which he finds himself, whether there is difficulty finding similar employment. But this might also be a relatively neutral factor. So there may be some secondary factors as well, such as poor health or poor language skills, but these factors don't seem to apply here. So given the marketability of Robert's skills and his particularly his length of service and his status in the organization, Phil Singer, the author of your textbook, recommended 4 to 6 months, and I recommend somewhere around 6 to 8 months. And so the average of our two recommendations would be about 6 months. And you'll notice that his length of service is 7.5 years. And so my recommendation covers that range of the length of service. This is not a legal test, so please never say this, never repeat this to anybody who wouldn't understand what I'm saying. But we know it's a sort of rule of thumb or a guideline for employment relations lawyers that a sort of starting point for reasonable notice periods is 1 month for each year of service. Now that is not, nowhere in the courts will you find that that legal test. So don't repeat it as, this is what the law requires. It's simply a guideline, a way to sort out whether the reasonable notice period goes up or down from there. Let me repeat that. Do not repeat this as a legal test, a test of something that a rule that's written into legal decisions. It is not. It is simply a shorthand that I have heard lawyers use at times to describe a quick and easy way to determine what reasonable notice period might be without going to court. So my recommendation falls in that range. Phil Singer, on the other hand, is a little shorter than that, and I can't disagree with Phil Singer. If you look at the reasonable notice period from the employer's point of view, probably what would be in their mind is that they would want to minimize the cost to the employer of successfully terminating the employee, and so you would want to pay just enough reasonable notice to have the employee go away without suing you and feel that they'd been treated, even if they didn't feel they were treated fairly, they would determine very quickly that they probably wouldn't get much more if they went to court, and so they wouldn't pursue a civil suit. So if I'm the HR practitioner, I'm trying to balance the needs of both the employee and the employer, and so really, I'd probably end up somewhere around 6 months for Robert, possibly even a little bit less, but probably around that 6 month period for me, and that overlaps with Phil Singer. So notice how what I'm trying to explain, it isn't a mathematical model, although what I showed you earlier was, my modeling, my mathematical modeling of actual reasonable notice cases, but in the workplace, it's rarely a mathematical model that would determine what reasonable notice period is. But that 1 month to 1 year is not a bad place to start. I will skip over this slide. Well, no, maybe I won't. One of the dangers of leaving a message for Robert rather than telling him in a face-to-face meeting, or at least, a phone message, is that the manner of dismissal can be considered somewhat insensitive and disrespectful if I don't, provide a candid explanation directly to the employee. And so in order to avoid a longer reasonable notice period, if that employee does go to court, then I want to be careful about the manner of dismissal. So I would, if I'm concerned about, the reaction of the employee, well, I'd probably do it in a more public place, not necessarily out in the open, but where there would be witnesses if anything untoward happened. So moving on, I mentioned earlier that the terminated employee who expects reasonable notice period also has a duty to mitigate the loss of the job. And so the employee is obligated to mitigate the economic loss with reasonable effort. So, think about if you were looking for work, what reasonable effort might represent. Are you sending out resumes? Are you inquiring with business associates or family? Are you are you pursuing the sort of normal avenues of finding whatever they are at the time that you're doing it, of finding new employment? If the danger for the employee is that if they are not seen to be undertaking reasonable efforts to replace the lost employment, the court may take back some of the reasonable notice period that they might otherwise earn as an award in the courts, or maybe even remove it altogether. And so the employee has this obligation to get out and look for new work. However, having said that, the onus, or remember the burden of proof, as in several other circumstances in the courts, the burden of proof is on the employer to show that the employee did not mitigate the loss. It's up to the employer to find that evidence, to provide that evidence. Or, for instance, to show that comparable or appropriate jobs were available and the employee didn't try to, acquire those positions. So a question comes up, what is a reasonable job search? And so in the courts, there's frequently this test used, what would a reasonable person do? Or what would a reasonable person think? And so it's a little bit tricky to determine that, but if you're making substantive, not overwhelming efforts, but substantive efforts toward finding new employment, that probably is enough to satisfy the requirement. Another question is, well, what is a comparable job? And so it would make sense, for instance, that if I'm the CEO of a fairly large company, replacing that job with comparable work probably doesn't include an unskilled labor job, in construction or something like that. So yeah, there should be a relative sort of comparability between the job sought and the job left. So this is a relatively interesting case, and as far as I know, this is still the law of the land in Canada. Another Supreme Court of Canada decision in 2008, a man named Evans, who was I believe a business agent, as it says here, for the Teamsters in Whitehorse up in Yukon Territory. And so Evans, there was a sort of political changeover in the Teamsters Union there, a hotly contested election, and Evans was terminated as the business agent for the Teamsters, a position he'd held for 23 years as a result of this, contested union election and the result of the election. So as it turned out, the parties negotiated a severance package for 5 months while the employer continued to pay Evans his salary and benefits. At that point, the employer told Evans it couldn't agree to his severance demands and asked him to return to work for the balance of his 24-month notice period. 24 months is as I mentioned earlier, is usually considered in the courts to be the top end of the reasonable notice period. So that's a pretty healthy notice period that they provided to him, that the Teamsters Union provided to Evans. And mind you, now he's also been, continued working for them for 5 months since he was provided notice of his termination. So he's been basically the employer has required him to work his notice period of 24 months, and he's already done that for 5 months. So Evans, at that point, after 5 months, he sued for wrongful dismissal damages, and the trial court, so this would be the lowest level court, the first level court that would have heard his case, awarded him 22 months of damages, less than the notice period that the Teamsters were offering him, but still a pretty healthy notice period. And that would have, and at that time, in the early 2000s, that would have amounted to about $100,000 in damages. So this case eventually ended up in the Supreme Court of Canada, which decided in a 6-1 ruling. Don't forget, the Supreme Court of Canada normally has 9 judges on the panel, but it doesn't need all 9 for a particular case. And in this case, there were 7 that heard the arguments. And so in 6-1 ruling, a majority ruling, the court held for the employer. And what the explanation they provided for that ruling was, where salary and working conditions remain the same and returning would not be humiliating to the employee has a duty to return to the same job to mitigate. So this is actually quite a 90-degree, right angle turn away from what had been essentially the law up till that point. At that point, an employee would normally be considered entitled to leave the employment and sue the employer, but the court is saying, no, wait a second, or to mitigate their losses elsewhere. But the court is saying here, no, wait a second, you had the opportunity to work out the balance of a 24-month notice period, and there wasn't a great deal of rancor or disagreement. I mean, you and the employer disagreed over, the notice period or the details of it, but you still had a relatively productive working relationship. So where that existed, you should return to that employment to mitigate your losses. And so in other words, the employee should have been required, or was required by the court, to work out the notice period. So working notice that we talked about earlier, and in order to mitigate the loss of their job. Of course, on the other side of this, in this case, the Teamsters would have had to provide time to Evans to do what was necessary to find new comparable employment. So the justice, who is Rosalia Bella, if any of you have studied with Dr. Dye, you might recognize this name. She was also the author of the Abella report back in the 80s on employment equity. She was the lone dissenter in this particular decision. And so we sometimes pay attention to the dissenting view, because sometimes it provides a compelling, a persuasive argument that the other justices didn't consider for some reason, but some other judge somewhere else might. So the employment contract is unique in that it is one of personal service. This was the law up till this decision, and expecting the relationship to pick up again as if nothing happened is not reasonable. So where my employer terminates me, that's essentially a fundamental repudiation of the employment contract. And so she's arguing, well, this is a personal, sort of service relationship, and so how could we expect Evans to just pick up as if nothing had happened? Um, and similarly, reinstatement to old job is not available to dismissed employee under common law. So one of the remedies that is available in labor law, as an example, in union settings, is that a wrongfully terminated employee can win reinstatement into their old position as a remedy to the wrongful dismissal. But that's not available in the common law. I don't want to make this overly complex for you, but if I'm in a non-union workplace and I'm wrongfully terminated, and that's determined by a court because I've sued my former employer for wrongful dismissal, the court can't order me back into my old position. There's an assumption in the law in Canada that a recognition, as Abella argued, that this is a contract, essentially a personal service. I can't contract out my employment to somebody else, and so it's personal service, and so the employer is not, under the law in Canada, the employer is not required to take me back if the court did want to reinstate me. Although that is true in union settings and some other settings as well, but particularly in union settings in Canada. So just to summarize again, reinstatement is not a remedy. Usually only reasonable notice is a remedy in common law. The contract is usually considered to be at an end, and so the employer owes you reasonable notice of termination. And so this particular case, Evans versus the Teamsters, seems to fly in the face of that assumption that we made up until that Supreme Court of Canada decision. It's kind of like, if this is good for the employee not being able to win reinstatement, why should the employee then be required to work out the balance of the contract? Anyway, so it's an ongoing discussion, but it does show up in subsequent decisions. So yeah, as I mentioned earlier, in the agenda, we would be considering constructive dismissal. And so this is a circumstance where the employer unilaterally and fundamentally changes the terms of or the conditions of work, perhaps with respect to job duties or geographic location, hours of work, compensation, perhaps laying off the employee where that wasn't contemplated in the contract, creating an untenable, this is an interesting one actually, letting an untenable work environment continue. For example, where an employer doesn't correct employees who are harassing other employees, or you can probably think of a whole range of things that might happen. It entitles the employee to resign and claim damages for reasonable notice, just as they would if they had been wrongfully dismissed. So it is essentially a dismissal that has been constructed by the employer. And so it relies on an objective comparison between the current job and the new job offered. So here's a case. Corey, 19 years of service, worked 4 days a week from 9 to 1, 20 hours per week, essentially half time. For legitimate business reasons, the employer decided to change her hours to 5 days per week from 8 to 2 p.m., which increased her hours to 30 per week. And Corey refused. And the basis of her refusal was that the 8 a.m. start time would be incompatible with her baby's schedule. The employer stated her last day of work would be in 4 weeks' time, and Corey sued. The court awarded her 15 months of notice. Don't forget, she had worked for 19 years in a relatively junior status, it seems, at this particular employer. And they also awarded her costs for constructive dismissal. So those would be additional costs above and beyond reasonable notice. So what did the employer do wrong? Well, they changed the conditions of her employment. And for 19 years, she'd worked under a certain set of conditions. And the employer, thinking that they could unilaterally and not arbitrarily necessarily, in the case it does explain that they had legitimate business reasons, but they changed the nature of her employment. A long-standing set of conditions of her employment. And so the decision went against the employer. Another example, Shaw versus Xerox, where the employer creates or allows intolerable working environment. The employee may claim constructive dismissal. The courts have found employers have an implied duty to maintain a safe, and I would add safe and healthy workplace, and to treat employees with civility and respect. You might, consider that this is kind of where human rights in Canada overlaps with contract law, and so if an employment, the conditions of employment, the conditions in the workplace, represent a kind of disrespectful workplace that might damage the dignity of the individual, and based on, well, it doesn't have to be based on a protected ground, but it might, but it could be on some other ground that isn't protected by human rights in Canada. But that the essential duty is that the employer has to provide a safe and healthy workplace, and in this particular case, they did not. Another example of constructive dismissal, Stamos versus Annuity Research and Marketing. And so the question before the court was whether constructive dismissal can arise if a coworker, not an employer or a supervisory employee, creates the intolerable conditions. Went to the Ontario Superior Court of Justice and found that the employer had a duty to ensure that the work environment allowed employee to do her job. So I don't remember the specifics of this particular case, but it seems apparent that this coworker was creating intolerable conditions. I don't have a description of what those might be, but the employer was found to be responsible for the actions of the employee. The employee who was creating the intolerable conditions. The workplace belongs to the employer, and the employer, as I said on the previous slide, the employer has a responsibility to provide a safe and healthy workplace, one free from indignities. So here's a case of constructive dismissal, and I believe this fact case appears in your list of questions for test 1. But before I go into this particular fact case, the previous case reminds me, or previous 2 cases reminds me of a story I read about Air Canada pilots coming back. They were on a route from probably Toronto to Las Vegas, and on the way back from Las Vegas, the male pilots would regularly leave pornographic materials that they'd picked up in Las Vegas on the flight deck of the plane, and a female pilot coming into that flight deck, encountered this pornographic material and found it undignified and aimed, material that was aimed at denigrating women and so on. And so the question was, well, is that the responsibility of the employer? And in this case, yes, the employer is responsible for the working conditions. The flight deck of an airplane are the working conditions for all pilots, male or female. And so the employer needed to take the complaints of the female pilots seriously and did not. So think about this though from the female pilot's point of view. Would I take this up as a human rights case, take it to a tribunal? In the case of Air Canada, for instance, that would be a complaint under federal human rights law, as that industry is regulated by federal law. Or would I, or I could take it to a court, a civil court, and claim constructive dismissal, as we've been discussing just now. That option is kind of up to the employee. Which route would they take? And I would probably have to make that decision based on specific legal advice. I'd go seek a lawyer and I'd try to find out what would be the best way for me to go forward. If I had 30 years of service with Air Canada, I might go the wrongful dismissal route, or the constructive dismissal route, because I might get 24 months of reasonable notice period. Whereas my damages in a human rights court might be significantly less than that. So there are these kinds of decisions that an employee might make in a case like this. But generally speaking, the rule of law, I guess you could say, is that the employer has an obligation to provide a safe, harassment-free, healthy workplace to employees. So in this current case, Davies was 63 years old and had worked as a debt collector for the employer for 5.5 years. One day, his employer advised him that it had lost a major client and would have to lay him off temporarily, effective immediately. The employer said he hoped Davies would be back at work full-time soon and informed him that his benefits would be continued in the meantime. Approximately 2 months later, the employer recalled Davies to work, offering him the same salary and position, although he had not found another job. Davies ignored the recall because he was upset by the way he had been treated. Instead, he sued for constructive dismissal, arguing that his employer did not have an implied right to lay him off under the terms of his employment contract. The employer argued that Davies had failed to mitigate his damages. How do you think a judge would decide this case and support your answer? Again, do that T account and make arguments for and against, and then construct your decision and supporting arguments from that. So this particular case is not entirely straightforward. First of all, it seems like Davies was constructively dismissed when he was temporarily laid off. So the assumption here is that in his contract, there was no provision for temporary layoffs. The employer had no basis for using, which essentially, it's not a punishment exactly, but the employer would need to, the employee, Davies, would have needed to agree to a contract that included the possibility of temporary layoffs. And the assumption here is that Davies did not agree to that. And so there's the element here of the employer adding a new condition, fundamentally repudiating the existing contract between Davies and the employer. And so this would constitute a constructive dismissal. However, Davies, arguably, because of the Evans versus the Teamsters decision of the Supreme Court of Canada in 2008, Davies arguably had an obligation to return to his former position when it was offered to him as part of his duty to mitigate damages. So it follows from the Supreme Court of Canada, as I just mentioned, the decision in Evans versus the Teamsters. The employee has the duty to mitigate, which includes returning to a position from which he or she was dismissed, where salary and working conditions remain essentially the same and working relationships are not acrimonious. Accordingly, Davies would only receive 2 months' pay in lieu of notice. So just to continue an explanation of that previous case, Davies, because of the Evans decision in the Supreme Court of Canada, Davies had an obligation to mitigate his damages. Well, he already had an obligation before that Supreme Court decision, but because of the Supreme Court decision, one of the ways that he could mitigate those damages was to return to the employer and continue working after the recall. He didn't do that, and so the court argued, or the court found, that he had failed the essential element of mitigating his damages, and so only awarded him that 2-month layoff as reasonable notice. In other words, Davies' reasonable notice period that he might have received from the courts was reduced from whatever length of notice period might have been appropriate down to 2 months. They took away probably a fairly substantial portion of his reasonable notice period because he failed to mitigate. Anyway, so how do we determine what wrongful dismissal damages should be? And the basic entitlement in Canadian law for reasonable notice damages is salary and benefits that would be earned in the reasonable notice period. A reasonable notice award is not damages to the extent, well, it's not punitive, I should say, to the extent that, in other words, it's not a penalty. What the court is trying to do is simply return the employee to the state they would have been in if the employer had followed their common law obligation to the employee, which, again, I'll repeat once more, is to, for any employee that is terminated without just cause, the employer owes a reasonable notice period. And so the reasonable notice period is, again, a period of time thought necessary to replace with comparable work the position that they've been terminated from. And so in that period, they would earn salary and benefits. And there may be benefits, well, we'd have to determine, and evidence would be presented in the court about what benefits to include. So there occasionally are questions about not only benefits. I shouldn't limit it only to benefits. There may be other compensation that could come into question as well, like periodic bonus payments or the vesting of some sort of compensation that there may not be a firm agreement on whether the employee was due. So there may be cases that still need to be argued in a court. It's not always that straightforward. But generally speaking, it is. It's salary and benefits. What would they have earned, let's say, over a 3-month period? 3 months times salary, 3 times the benefit, the value of benefits. So benefits, some of the things that might come up are benefits might include, a company car, insurance. So for instance, your professors, we generally, the full-time ones, are paid or benefit from disability insurance, life insurance, health insurance, dental insurance, and and pension contributions and things like that. We don't get a company car. No, Acadia does not provide cars. But there are a number of benefits, and generally speaking, in Canada, benefits can be somewhere between 10 and 20% maybe of our wages or our salary. Sometimes higher, sometimes lower, depending on the type of employment. I don't know where your faculty, your professors' benefits might fall. I don't think it's as high as 20%. I think it's actually closer to something like 12% or something like that. But even just our pension contributions alone are matched by the employer at a rate of about 8.5%. So just the pension payments alone are quite significant. Any work-related expenses and sometimes controversial is this item number 7. Did the question before the court or the argument made by the employer is sometimes, well, the employee, didn't earn this bonus because they really weren't employed by us anymore, or the stock option or profit sharing or something like that. And so the court has to look at the facts and determine whether the employee would have earned these things in that reasonable notice period. So, if the bonus was awarded during the notice period, the employee probably was due the bonus, but it depends. And so it's a relatively, it doesn't happen as often as, so it's not as, it's important, but it's not as important in the general cases that you're going to consider in the workplace, but it does come up. And so there may be some other damages that come up if remember I said that, for instance, that reasonable notice period is it's simply from the court's point of view, it's simply the court trying to put the employee back in the position they would have been in if the employer had honored or carried out their obligations under common law in Canada to provide reasonable notice of termination. But then occasionally the courts may find that the employer acts in a way that is punitive and will award additional damages. And so there's a category called punitive damages, an extra penalty that might be added. And of course, I've already referred to the Wallace extended notice, or sometimes referred to as augmented damages, which refers to the manner of dismissal. Was there some kind of damage done to the employee in the manner of dismissal? So in the original case against Wallace, the employer argued that, well, they argued, first of all, that they had just cause for termination, and they maintained that argument right up to the eve of the trial, the first level trial of civil court case that Wallace brought against them. And so they did damage to him psychologically. He had to seek out professional help for his depression or whatever condition he was suffering from. And he also, the waters would have been poisoned in a sense for him to find new employment, poisoned by the employer by alleging that they had just cause when in fact they didn't. It could have made it much more difficult for him to find new employment. So these were real substantive damages caused by the employer in the manner of dismissal. Now, one of the, I mentioned Keys versus Honda earlier. One of the reasons, well, I really don't want to delve too deeply into Keys, but one of the things that came out of Keys, probably the key thing to come out of Keys, was that the court limited, there was an argument being made that Wallace damages, or these so-called augmented damages, were getting somewhat out of hand, that the argument was being made and perhaps overly generous damages were being awarded by some courts as a result of arguments made about the manner of dismissal. And in one of the primary sort of findings of the Keys decision that is kind of important to remember is that Wallace damages or augmented damages should be limited to real damages or substantive damages. So as I mentioned in the Wallace case, there was psychological and job replacement damages done to Wallace. These were real damages done to his ability to earn a living and his quality of life. But so just terminating somebody, as an example, unless every employer has the right to terminate an employee in the absence of other agreement, as long as they provide reasonable notice. So so it's got to be the manner of dismissal causing real or substantive damage. So even though I've spoken about it quite a bit, I didn't really explain the Wallace decision to you. The original decision and a summary of the facts were in our very first module way back at the beginning of the semester. But basically, Wallace was, I think I've got all the facts correct here, but he was 56. He'd been with United Grain Growers for 14 years. He had been induced. Remember, we talked about this earlier, that inducing an employee to leave secure employment and then subsequently terminating them can lead to extended notice period. So he was induced to leave a secure job where he'd been for 25 years before his time with United Grain Growers, and in both workplaces he had been the top salesperson for almost 40 years. He's a top performer. And so despite being a top performer, the employer terminated him after he complained about commission rates. And the employer made and maintained unfounded allegations of misconduct up until the time of trial. And in the trial, it became, the evidence produced showed that the employer had decided to play hardball with Wallace. In other words, they decided to make an example of him. You know, how dare this salesperson, this uppity salesperson, demand higher rates for commissions? And so these allegations, which they never substantiated, even at trial, had a serious impact on Wallace's health and his job search. And so the court, and this went all the way, eventually all the way to the Supreme Court of Canada. He won a notice period of 22 months, and they decided that his notice period should be extended by 2 months to reflect the bad faith, and this is a frequently used term, bad faith, in manner of dismissal. Both the employee and the employer are, the expectation in law in Canada is that both will act in good faith. And so in this case, the employer acted in bad faith against Wallace. They made an allegation that was unfounded, first of all. So they should expect to be corrected severely by the court. And so 22 months is a long notice period, given that he had only been with United Grain Growers for 14 years. So I'll finish up with one final case. Wayne, a truck driver for a steel transportation company, hired in August 2012. In early November 2012, he brought his truck in for service, and on the way home, he noticed that his replacement truck was faulty. The steering wheel was loose, the mirrors had cracks in them, there was no engine brake, and fuel was leaking from the caps of both fuel tanks. The next morning, Wayne called the dispatcher to say he would not drive the replacement truck to haul steel because it was unsafe. The dispatcher asked him to haul one final load back to Hamilton, which he refused to do, and his supervisor then called and, after a heated discussion, told him he was fired. Wayne filed a complaint saying this was a reprisal for his exercising his right to refuse unsafe work. The employer countered that Wayne was still a probationary employee and therefore could be terminated for any reason. And in addition, he was fired for cause. The employer claimed Wayne swore at the dispatcher when he called in about the replacement truck, which Wayne denied, and that Wayne had failed to return another driver's CB radio in a truck he had started using. So whose arguments do you think would be successful, Wayne's or the employer's, and support your answers? I'm not sure if this one shows up on test one material. I'm actually thinking it doesn't, but don't count on it. So this case is based on a real case, Barber versus LP Services, which you can find on CanLE, the online legal case service, publishing service. And this is not in a court necessarily. The Ontario Labour Relations Board, it may have ended up in a court eventually, but it highlights the right, the employee's right to a safe, healthy workplace. So in the Labour Relations Board hearing, the board found that the employee, Barber, or in my case, in our case, Wayne, was exercising his right to refuse unsafe work because he had good reason to believe the replacement truck wasn't fit to haul steel. And of course, he's also probably considering the health and safety of others on the highway. So because Wayne had promptly reported his refusal and the reasons for it, the employer's failure to immediately investigate his report violated his right to refuse unsafe work conditions. And so you can see here where I mentioned earlier how human rights principles can overlap with into common law, and here we have health and safety principles overlapping or not intruding exactly, but creating conditions in the common law as well, or creating arguments in the common law as well. So the court argued, or the board argued, that although the supervisor claimed that the complainant had been aggressive with this dispatcher, the board found his denial credible because the dispatcher was not responsible for assigning him with the replacement truck. So there were, in other words, there were mitigating factors here, and the board took them into account. Moreover, to explain his behavior. Moreover, even if the CB radio incident occurred, it was not relevant because the employer had not warned him that his conduct was unacceptable. Finally, so it's sort of like a separate, complaint. Finally, complainant's status as a probationary employee was irrelevant because the parties cannot contract out of occupational health and safety standards. And a lot of employers, and probably a lot of students too, assume that if an employee is probationary, that the employer does not need any reason, any cause for dismissing a probationary employee. But generally speaking, in both labor and non-union workplaces, it's generally there must be some cause. It doesn't have to reach the same kind of level of the same standard for a non-probationary as it does for a non-probationary employee, but arbitrary dismissal of a probationary employee, the courts really don't like that, and arbitrators generally do not like that. And in this particular case, I would also argue that the Labor Relations Board argued that a violation of the Health and Safety Act is also, tantamount to bad faith. It is the employer's duty to respect the employee's right to reject unsafe work. That is a fundamental right in Canada. And so the employer is essentially acting in bad faith. And so the employer was ordered to pay back pay for the 4 months since the termination, plus an additional 4 weeks of reasonable notice, which came to more than $20,000. So now I know this may not sound like a huge settlement, but the principle is clear. I'm not sure that they argued about the probationary status in the original case, because I haven't read the original case, but that is the point in Canadian law. Don't take for granted that probationary employees can be dismissed for any reason, and if you're treating the employee in bad faith, if you're dealing with them in bad faith, you're gonna get slapped by an arbitrator or a judge. It's just deal with people on a good faith basis, if you want respect from the courts. Anyway, so an interesting case to highlight several ideas, including that this is essentially a constructed dismissal because the employer was not concerned enough about the health and safety, not only of the driver, which is primary importance, but I would argue in the background, the employee, the driver, was doing the public a service by not driving the truck. Imagine taking a truck out on the highway laden with steel that is defective. Brakes were not working effectively, the mirrors were cracked, and so on and so forth. These are important considerations. A slippery slope if we let employers get away with this. So a good decision.